Good morning and welcome to this year's Surviving Caregiver Conference, everyone. We're happy to see you all. I am Lisa Phillipson. I'm the Community Relations Director for Hospice of Southern Illinois. And like so many things over the past year, our conference has changed how we're doing things. Instead of a Saturday afternoon and morning, we're moving it to 4 Saturdays consecutively in a row. And one thing to remember, every Saturday it will start right at 10 a.m. So you can put that down in your calendar. I am proud that Hospice of Southern Illinois has partnered with St. John's Community Care and Age Smart to bring these wonderful programs to you. We hope that you find them valuable and very supportive to everything that you're going through and doing. Next week, we will have the adapted equipment and caregiver folks. They will be presenting on improving safety and function for loved ones and caregivers at home. On April 24th, Memory Care Home Solutions will be bringing practical strategies for you as a family and caregiver for your loved ones. And on May 1st, St. John's Community Care, Age Smart, and Hospice of Southern Illinois will be speaking to all of you and helping you age well and in place. So we're going to bring you all that information. One thing, a little housekeeping for everyone. We are going to do question and answers at the end of the program, not during it. We ask and invite you to use the Q&A part of the Zoom to ask your questions. And my cohort, Chris Fulton, will be handling those questions toward the end and making sure you all know how to get the surveys in. Right now, I want to thank Heidi Dodd, the owner of Harter, Larson, and Dodd. She is so gracious and joins us every year for this. This is valuable information for everyone. Heidi practices law for Harter, Larson, and Dodd, and she is in O'Fallon, Illinois, in the areas of estate planning, probate, guardianships, trust administration, elder law, Medicaid planning, asset preservation, veterans benefit, real estate. Ms. Dodd is an accredited attorney with the Department of Veterans Affairs. And prior to entering private practice, Ms. Dodd served as an assistant general counsel for the Illinois Department of Aging. Heidi, we can't thank you enough for every year helping us with this. Everyone sit back. She will have handouts that we will be emailing to each of you, but I would take notes. This is valuable information, and we are always so thankful that she does this for us. Thanks, Heidi.
Thank you, Lisa. Good morning. I'm always grateful to be invited back to this. This is my favorite place to speak every year. I always say it's the only place I'll take a Saturday speaking engagement, but I love it because this caregiver conference is incredible. The people who put it on, Lisa and Chris and Age Smart and St. John's and all of the sponsors are an incredible, valuable resource in our community for caregivers and their loved ones. And so I'm so glad everyone is joining us this morning because it really, truly is great information. And I love speaking about it. So let's get started. I'm really hoping today to cover just kind of more of the legal aspect and tie that into caregiving. And so I think the first step as a caregiver, it's important that you're here this morning because that means you're reaching out, you're looking for resources, you're trying to make sure you've got all of those things at your fingertips, which is critical because if it wasn't for you, your loved one potentially would be in a facility or would be wouldn't be at home and you wouldn't be able to care for them. So it's important as caregivers, number one, that you take care of yourselves. I wasn't truly a frontline caregiver. My dad passed away 16 years ago from Alzheimer's, but I certainly was involved in his care. And so it stages, right? It stages whether it's dementia, whether it's another type of long-term illness or terminal illness. It takes a toll on both the loved one who is going through the illness, but also those caregivers and the family. And so it's truly a family affair. And I think it's important as caregivers when you realize you're truly stepping into that role, whether it's part-time or full-time or your loved one is needing that additional care, that you make sure that your loved one's affairs are in order. And it doesn't hurt for you to make sure your affairs are in order too, because it is not uncommon for me to see a spouse take care of their loved one or their spouse as a caregiver. And sometimes they conk out on us before the person with the terminal illness does, because they just don't take care of themselves. They push off their own doctor's appointments. They push off their own care, and they ignore their signs and symptoms of something that might be going on with their body. So please take care of yourselves, and that helps you also take care of your loved one. And so I'm going to start with kind of going over what it means to get your affairs in order. I really look at this as getting your legal documents in order. So everyone over the age of 18 needs advanced directives, and then at a minimum, a last will and testament. So that advanced directives, in my mind, which is kind of a fancy term for a power of attorney, that's what all of us typically refer to. There are several types of powers of attorney. There is a healthcare power of attorney, and this is really in advance, your advance directive, you are choosing who in fact will make medical decisions for you if you're not able to. And so it's critical that we get those in place, especially if you're going to be a caregiver or are a caregiver. And you're likely the one who's taking your loved one to the hospital, to the doctor, to those, to those weekly appointments or those monthly checkups. And so that's what's important, is getting a healthcare document in place while you're still competent, before you lose capacity or before your mental well-being is not there. And so we typically, when I execute those healthcare powers of attorney, I always ask my clients to name at least one, at a minimum of one person, because sometimes we just have the one person. But if you can think of at least two people, that's really where I think is important, is to name two individuals who, in order. So, if you have children, maybe you name the one who's a nurse, or maybe you name the one who's in the medical field, and then, name them in some sort of pecking order. I don't have a problem putting 3 or 4 people on there, because once in a blue moon, something odd happens. And once you get these advanced directives in place, you want to be able to rely on those people. So at least be able to name 2 individuals that can act as your agent. And that means when you're not competent, they can step in and they can conduct themselves with the physician or any of the medical individuals that they're working with on your behalf, and access medical records and talk to them and help make decisions. Typically, we think of powers of attorney for health kind of end of life, and sometimes that's it. Everybody's calling their shots because they're mentally capable of doing that up until the end, when they're no longer competent or have slipped into a coma or something, and they're just not waking up. So it's important on that medical directive to pick people that you trust and who will honor your wishes. For example, I always say, sometimes my clients will say, I want to be cremated. And the kids will say, oh, I don't want to do that, Mom. I don't want to do that with you. Well, you need to choose someone who's going to honor your wishes. Because ultimately that's the whole point of an advance directive. Someone you trust, somebody who will honor your wishes, and someone who you think has your best interest at heart and will, be a great advocate for you in the medical world when you're not feeling up to it or not able to. And so often I get a question on the healthcare power of attorney is, oh, I chose the child who lives the closest. Sometimes that's the right person, but don't feel like just because the child who lives the closest has to be the one named. In this day and age, now we're doing Zoom for this conference. Things can be done electronically, things can be done over the phone, decisions can be made pretty quickly as long as you can reach that individual. So I think it's more important that you choose the person who will honor your wishes and who will carry out your desires than necessarily the individual who's closest in location. Sometimes it's the same person. It's the child who lives closest to you who's also the one who, would honor your wishes, and you want to make those decisions. So it's fine either way, but just keep that in mind. People often think they have to pick somebody who lives right next door, but maybe that's not the right person for medical, or maybe that individual is better for financial. So, and I always say, if you have multiple children, let's split up the duties. So you have the healthcare power of attorney, and also under the healthcare power of attorney, you direct your agent on kind of end of life wishes, how you want your affairs to be handled. Do you want life sustaining treatment? Do you want to be held to that standard and kept on machines indefinitely, or do you want to be able to die naturally and comfortably? Do you, how many extraneous measures do you really want at end of life? And so not only is it important to pick the person who will honor your wishes, but it's also important that you share your wishes with that person. And healthcare power of attorney also, I kind of alluded to it earlier, does extend to burial. And so powers of attorney typically end at death, but a healthcare power of attorney extends to the funeral. So you can handle the disposition of someone's remains. And that's important, because sometimes families are going to fight. They're going to fight about everything. So sometimes families get kind of sideways about which funeral home we're going to, who's going to make the final decisions. And so you want to get that person in place, and then you want to share your wishes. And I always say, it's a gift. It's morbid. I know nobody wants to go plan their funeral, but it is a gift that you pre-plan your burial, if at all possible. Pre-plan, prepay, and we'll talk about why that's so important later in this conversation. But healthcare power of attorney in general helps designate an individual as an agent to step in and make decisions for you when you are not able to make those decisions for yourself. So it's important that you have that document in place. The next advanced directive I want to cover is the financial or property power of attorney. And again, very important to pick somebody you trust. You trust who will handle your finances. You trust who will manage your affairs if you're not able to. Maybe it gets down to you're in a long-term care situation. You're no longer able to live at home. You're going to have to sell your home to pay for your care or to live with that loved one, and you need that money, or the house is just sitting empty. So it's kind of useless to, keep it sitting there and pay all of those expenses when you're not going to return to your home. So you have to trust somebody on the financial power of attorney who has your best interest, who will play ball above board. The biggest concern I always have with financial powers of attorney is obviously elder financial abuse. Unfortunately, a high level of the financial abusers are typically family members who are close with us. So you have to pick a family member who we trust, who will handle your affairs honorably, and keep those funds separate, right? That's the most important thing. And it's important that whoever you choose as your agent, again, distance isn't a big deal. If your son out in California is the right person, most of the stuff can be done electronically. Maybe he has to fly home. Who knows? But it's probably not a bad thing if he needs to fly home to see you. But it's important to name somebody who is good with money, who you trust, who will be above board, and who has somewhat financial savvy sense and can handle your investments or help pay for your care and know kind of where to turn. And I also like, just like the healthcare power of attorney, I think it's critical that you not only have a first person name, but hopefully a second agent. So oftentimes we name our spouses first and then our children in some sort of pecking order. I often tell people for both the healthcare and the financial power of attorney, you have to name a pecking order. So one at a time. We don't do co-agents anymore. The law no longer allows for that. So I think that's important because sometimes people want their kids to be on the same playing field and feel equal. So I said, if you want to make them feel equal, pick one for medical and pick one for financial, because that also shares the burden. I recently met with a family and the one daughter has moved her parents in to care for them. And so she's handling the medical, which makes sense because she's the one living with them day to day and managing their care. And she's the one taking them to the doctor's appointments, where the other child who doesn't live in the home is very financial savvy. So she is taking on that responsibility. And the parents, they chose, after meeting with the family, obviously I thought that was a good choice because the daughter with the financial, she's taking on those burdens. And both healthcare and financial powers of attorney have a lot of responsibility going on with them. So if you have one person kind of helping manage your checkbook and make sure your bills are getting paid and everything is on time, and the other one managing your care, I think that that's a good division of, or I would say, division of duties. So under the financial power of attorney, we also, our agent can reach out to, our life insurance, our IRAs. And that's what's important is if we get into a long-term care situation and we need money to pay for care, if we're no longer to care for our loved one at home, then you want to know that they can reach out to those places and make some connections and make some things happen and make some money available to help pay for your loved one's care for that individual. And so oftentimes some of the kind of the misconceptions with the financial power of attorney is, hey, my kids are beneficiaries. I've named them as beneficiaries at my death of this account. They can get to it. They can't. So if you name a child as a beneficiary on your life insurance policy, that's great. So at death, the life insurance will pass to those children, but it's not helpful during your lifetime if they need to call and get information about the life insurance policy or obtain information on your IRA. So it's truly important that you make those decisions on who those individuals are going to be under your financial property power of attorney far in advance before you lose any sort of capacity or, God forbid, have some sort of emergency accident. As well as just kind of knowing that they can reach out to those individuals, it's just important that you know that when somebody steps in on your behalf under financial power of attorney in healthcare, you can make those powers of attorney effective immediately, which means that person, could step in at any time. Or you can also just wait and make those powers of attorney springing, which means they don't spring into effect until you lose capacity. So sometimes that's a nice, we do that very often. It's just kind of a nice barrier. This is one more hurdle they have to get over before they step in, so that you continue to remain control of your assets. Oftentimes, if it's a spouse, we may make those effective immediately. I always kind of give the example with my spouse. So our powers of attorney are effective immediately, and there was a moment in time several years ago when we went to purchase a car, and I had to go purchase it by myself because my husband was homesick and my daughter was home. They were all homesick with strep. So I used his power of attorney to, help me complete that transaction and get his name on the title. And so I know that's kind of a silly example and doesn't necessarily apply to caregivers in that situation, but it shows that some powers of attorney are okay to be effective immediately, but it's also okay to make those powers of attorney springing, which means before the agent can step in on your behalf, they're going to need a physician's affidavit that says, yes, Harry Smith is no longer able to handle his affairs, and so this individual can step in. So I think it's a nice little protective barrier. It doesn't hurt. Okay, moving from powers of attorney, I want to kind of talk about other estate planning documents. And so these aren't necessarily advanced directives because that's more of our healthcare and our property powers of attorney, but just kind of talking about last will and testament and trusts. And so with this, I always say everybody needs a healthcare power of attorney, a property power of attorney, and a minimum of a last will and testament. And a last will and testament is really your ability to put in writing who gets what at the end of the day. It's important that you appoint executors. I like to, again, name multiple executors. And that way, if something happens, usually name your spouse and then maybe some of their children in a pecking order, that there's other people to step in. And not only do we need executors, but we also need to give directives on how we're going to, how we want those individuals to dispose of our property. So it's important that you think about that. Oftentimes my clients have specific gifts they want to give. Little Sally gets my jewelry, little Billy gets all the fishing poles, or dad's guns, or the gold coins are to be split. So think about those things. It's important that you put some thought into your last will and testament, because this really is your final wishes. And it's important that you line those out and that the individuals on the receiving end have that in writing. So a lot of times my clients will say, they'll just figure it out. But I know I want little Susie to have X, Y, and Z. Well, then let's put that in there. So if you have an idea of some specific items or specific gifts or how things are to go, it's really critical that you tell your attorney that and that they're able to put that in the will, because truly you don't want people guessing at the end of the day. This is kind of how you want things to go, not how you want them to guess at it to go. So last will and testament is important. It's just as equally important as getting powers of attorney in place. If you do a last will and testament, oftentimes I get, do I really need a will? Because I've made my children beneficiary on my bank accounts. I've made them beneficiary on my life insurance. There's really nothing else. Well, believe it or not, there's almost always something else that we forget about. People forget about those little Gerber life policies that your parents took out on you that are like $1,000. People forget about stock. If you have Prudential or MetLife and you had a policy, they always spin off on stock. So people forget about those little kind of items that bubble up throughout the years. They forget to put beneficiaries on them. They forget to list them in the will. And so, again, life insurance always kind of sometimes gets forgotten, and these little policies get forgotten, or you take out a CD at the last minute. You don't put anybody's name on it to be transferred at death to another individual. So it's important that you have a last will and testament. If you don't have a last will and testament at your death, the state of Illinois and the statutes under the Probate and Will Act will tell us how your assets are to be divided. So sometimes that's not our intent, right? If you have a spouse, if you don't have your beneficiaries on assets, it can be split up, maybe unintentionally, not how you want. And so it's not advisable to skip doing a simple will. At a minimum, everybody should have a very simple will, powers of attorney for healthcare and power of attorney for property. And that at least is a good comprehensive little package of what's needed, when we get to those difficult decisions in life, especially powers of attorney. If you don't get powers of attorney in place, because you just failed to get them in place before you lost capacity, or B, you didn't have capacity to sign those documents, then the alternative is a guardianship. So I kind of want to touch on guardianships out of the gate with this. So most people kind of cringe their nose at guardianships, and really what it means is that those loved ones either didn't have the capacity to get, they were past understanding. They weren't able to understand what they were signing. And I take that very seriously. If my clients are not competent to sign, then the alternative is perhaps petitioning the court to get a guardianship. And so guardianship kind of steps in line and replaces what a healthcare power of attorney and a property power of attorney would do. So again, when you plan in advance with the powers of attorney, you avoid the guardianship aspect, which is, it's just jumping through more hoops. It's more costly because we have to go to court and you have to file an annual report with the court and let the court know how this person is doing and attest to how the finances are being spent. So that part's not a bad thing. It's just jumping through more hoops. I remind people, even if you just have a power of attorney and you're acting under it, anytime a child steps in or any agent steps in under a financial property power of attorney, I always remind them, you still have a fiduciary duty. I say draw a line in the checkbook. On this date, April 5th, I took over paying mom's bills. This is what the balance was. And then you have to prove to mom and to anybody else who wants to, any beneficiaries or siblings who could question you later on down the line, that you did everything above board. So it's critical to keep really good records. So when you appoint that person under financial power of attorney, make sure it's somebody who's good with finances and B, who keeps good records, because they have a duty to be able, it's full disclosure, to be able to show, yep, this is all the bills I paid for mom, and this is where her funds are at this time. So that's important. And the flip side of that is, if you need a guardianship, you're going to do the same thing in the guardianship. You're just reporting to the court annually to tell them, this is how I'm handling mom or dad's affairs, and this is, how we're spending the money. At that point, perhaps they're in a long-term care situation or a facility, and, you're using that money to pay for their care monthly. So important to try to get those advanced directives in place before someone loses capacity. Because again, if not, then you're kind of alternatively stuck with the guardianship. And same thing with the last will and testament. If for some reason you don't have one in place, we may have to probate if there are assets that trigger probate. And I always like to explain to people, probate in Illinois is triggered when a decedent passes away and they own real estate just in their name. So maybe mom and dad owned a house together. Mom passed away 10 years ago. Dad just recently passed. They never cleaned up the deed. So the deed's just in dad's name. And that's okay. It's just one of the things that will trigger probate. So real estate in the decedent's name will trigger probate, or assets of $100,000 or more will trigger probate. And so that's important to note too. But the assets of $100,000 or more means there was no beneficiary on that account. There was no named, it was not TOD or POD, which is transfer on death, or payable on death to some named individual. And so it's important that when you acquire assets, and this is always a really good time as a caregiver, and while your loved one is competent and able to still get their affairs in order, that you sit down and do a comprehensive list of all of the assets, all of the insurance policies, all of those little policies they buy at the bank for $1,000. They're like $1,000 policies, accidental life, accidental death, or just those little life insurance policies. It's important that you take stock in everything: bank accounts, life insurance, IRAs, annuities, all those sorts of things. Maybe you retired with a pension and they had a small life insurance policy that you don't pay on, but it's there. So it has a death benefit. So you want to make sure you take stock on all of those, and then make sure while your loved one's still competent, you can sit down with them. They can call, they can check and say, hey, how is this titled? Is it just in my name? And who are my beneficiaries? So we make sure we try to cross all those T's and dot those I's prior to losing any sort of capacity, because only us as individuals can update our beneficiaries. Nobody else can do that for us. And so, and that's another misconception. People think with the power of attorney, they can kind of make those decisions, but they really shouldn't be. It's really my decision as to who I want on my IRA or my life insurance or my CDs or whatever. And so you want to make sure not only do you have those documents in place, but that you take it one step further. You take stock and inventory on every asset, and you make sure that those are titled correctly, and that there's beneficiaries on those. So that's super important. Okay. I see questions popping up, but I think I'm supposed to wait to answer those at the end. Sorry, I got a little distracted there.
Well, Heidi, I mean, if you want to answer them now, that's fine with me.
I'm so used to when we're in person, we just kind of go back and forth, but I'm fine with that.
Okay, I can give them to you now.
I see them.
Okay, First question we have, if someone is still coherent, is it ever too late to establish a trust?
It's a good question. So that was going to be my next topic after talking about wills. So that was perfect timing. So is it ever too late to establish a trust? If you're coherent, meaning, and you're competent, you can tell me who you are, who your children are, where your assets are, kind of what's going on. And I always meet with my clients alone. I'm not going to allow children to sit in there and prompt parents, So, but yes, if you're competent and the attorney feels that you're comfortable kind of knowing what your affairs are, I don't know if it's too late to establish a trust, but you should be able to sign documents for powers of attorney and a will and possibly a trust. So let's talk about what a trust is. So at a minimum, we need power of attorney for health, financial, and a last will and testament. And then another advanced planning document or estate planning document is a trust. Most of us know revocable living trusts. A revocable living trust is really, I was just talking about probate, the two things that trigger probate, which is real estate that's just in your name or assets of $100,000 or more that did not have a beneficiary or weren't joint with someone. So typically, like when the first spouse passes, all the assets are joint and, you have joint bank accounts and that sort of thing, and they all just naturally pass. With the trust, that helps us avoid probate. And I'm talking about a revocable living trust. So there are two types of trusts that I kind of work with in my world, which is revocable, which means you're in control, the individual who set up the trust. So mom or dad who sets up a trust, they're in control of their trust. When you sign a trust, you kind of wear all the hats. You're the trustee, you're the creator of the trust or the grantor, and you're the beneficiary. Because really, it's just an estate planning technique to help us avoid probate. It's also helpful to do a trust in multiple situations. Maybe you have children who are in their 50s but still can't handle money, and you want to do some sort of subtrust, like when you pass that their money is held by somebody else for their benefit, but that they can't just reach out and grab it. So there's multiple reasons we do a trust. A, to avoid probate. B, to protect some spendthrift kids, or they just are going to fly through money. Or maybe we have a special needs child or a special needs grandchild that we want to leave money to, but we don't want them to lose their benefit, their government benefits. Or we know that they're never going to be capable of managing that money. We don't want them to be taken advantage of. And so we set up a subtrust. That's another reason to do a revocable living trust. But what's important to note on this revocable living trust is that it is your parents, whoever's the creator of the trust. It's their asset. They're in control of it until they lose capacity. And for a trust to work, you actually have to fund it. So if we have I don't know why Harry Smith is stuck on my brain, but if we had the Harry Smith Revocable Living Trust, Dad created a trust, Harry Smith, we need to also actually retitle the real estate into the Harry Smith Trust. So you have to do a new deed. And then you have to retitle those assets, from that were in Harry Smith's name. You can either retitle them into the name of the trust, or you can name the trust as a beneficiary. There's multiple things. Your attorney should be able and be well poised to kind of go through those line by line with you. Oftentimes you have to make those transfers into the trust. They don't want the attorney to sign those documents. They want you to sign them. They want you to go to the bank and say, hey, I have this savings account and I want to title it into the Harry Smith Trust so that it passes how I want it to pass at the end of the day. Speaking of that, though, I want to back up really quick and just mention, oftentimes people ask me when we're talking about trying to avoid probate and beneficiaries on accounts, oftentimes people ask me, hey, I'm just going to add little Susie to my bank account. Well, we do that for convenience, right? We add them to the bank account because you want to know that in case of emergency, little Susie can keep paying my bills. And that's fine, unless you have a really, really large, if you keep 100 grand, 200 grand in your bank account, maybe just know that you don't have to add little Susie. She can use the power of attorney if you lose capacity for property. And so I always warn people, if you add little Susie and you have 3 other children, that account passes to little Susie at death. It's a joint ownership account. And so that can, I always tell my children, you got to share that money. That was really the intent. You were on there for convenience. Typically the intent though is that, she'll share it. So So I tell clients, don't put their name on it if you don't think that's going to go down correctly. But I also understand that a lot of it is convenience. It's just kind of creating the ease. But know that to avoid that kind of putting one child on everything and knowing that they're going to share it with the other children, it can cause a lot of problems on the back end when you pass away that were unintended. One of them is they end up not sharing it with the other children, and that's a problem. That was, certainly wasn't your intent. The intent was to go equally to all the kids. The other problem is if it's a large account, then little Susie is now gifting to her siblings. So she could have a tax problem. If you gift over $15,000 a year to individuals, I can gift $15,000 to everybody I know. But if I give $15,000 in a penny, I have to raise my hand to the IRS and advise them that I have gifted $15,000 in a penny to Sally Smith, Harry Smith, whoever, Tommy Smith, and that that goes against the gifting that in my lifetime that I'm allowed to do. Now, currently, that wouldn't be a problem for me because the gift exemption and the federal gift exemption is $11.5 million. We can gift up in our lifetime before we start having tax issues. Most of us aren't going to have those problems. And if you do, you don't need to go to Heidi Dodd. We need to send you to a different attorney because that's way over my pay grade. But anyways, kind of the concept is, parents do those things. So I'm just trying to throw out things that I see that can also pose problems later. So you don't necessarily have to add little Susie or little Johnny to the account. They just know that they can always exercise their power of attorney and present that to the bank when you're no longer able to handle your affairs. Okay, I'm circling back to the trust. Revocable living trust. So when you create that, A, it helps avoid probate. B, it helps create subtrusts, and it makes it easier for assets to transfer at the end of the day. But what is so important, and the misconception that many of my clients, they've done these trusts 10, 15 years ago, and they come back in, and now they're aging, they're facing some sort of long-term care illness or long-term care facility entry, and they think that their trust protects their assets. It does not. A revocable living trust is the individual's asset. They're still in control of it. They're the beneficiary of it, and it does not protect it from having to pay for your long-term care. So that's a huge misconception that I want you all to know. It has lots of good reasons to do it, but one of them is not protecting your assets. So another type of trust that we often look at is, I'm getting sideswiped by this question, sorry, is a irrevocable trust. So oftentimes when we're at the caregiving stage and a loved one is needing some sort of long-term care or facing an illness, then you want to know, how do I protect mom or dad's assets? Or mom or dad says, how do I protect my assets? So that's kind of getting into the irrevocable trust world. All right. That's a lot more complicated planning. That's kind of when we talk about more of like Medicaid planning, VA planning, asset protection trust means it's a big deal though. So a revocable living trust, you're in control of your assets. An irrevocable trust, you are gifting your assets. You're going over the $15,000 limit. You are gifting those assets away to an irrevocable trust of which you can no longer control, and you are no longer the beneficiary. So the concept is, I want to protect X amount of assets for my children so that they have some sort of inheritance or whatever your reason is. But you have to know that there's a 5-year look back on the transfer of those assets because you are getting rid of them. You're getting them out of your name and you're trying to divest yourself of assets. And so the state of Illinois and the federal government have imposed, it used to be 3 years and now it's 5. So there's a 5-year look back on the transfer of assets because you're transferring them for less than fair market value. So that's important to know. And you lose control, complete control. And it's typically you're giving up control either to a corporate trustee to manage those funds or your children, maybe some co-trustees or the kids kind of take care of those things. So you have to really trust your trustee and you have to really be okay with giving those assets away and not being able to reach back out and grab them. It's a big deal. Oftentimes when clients ask me that, then they're like, nope, I want to stay in control. All right. And quite frankly, your assets are there for your use and benefit. You've amassed these assets. You've paid off your home years in advance of retirement, and that's equity of your estate. And so, so some people, once they realize they lose control, they don't want to lose control. I mean, there's a myriad of reasons why you would do an irrevocable trust, but primarily they're focused on Medicaid planning and asset protection. So I don't know if I answered that question perfectly, but I think so. Okay. That's irrevocable trust. But that leads me to having a conversation about this 5-year look back. So the 5-year look back goes into what kind of my next subject was going to be to cover is how to pay for long-term care. Right. So there's multiple ways to pay for long-term care. First, it's private pay. We're going to look to what funds do your parents have? What or you have? What is your income? Right? Your pension, your Social Security. Those are your monthly incomes that are steady. So we look at what is your income, and maybe some of that's income off of an investment. Who knows? Some people often, will say, "Oh, I get $600 a month off of my IRA or something like that." So that's considered income too. But they're looking at your income, and then they're also looking at your assets. So private pay means we're going to see how much income you have coming in a month and how many assets you have after the income isn't enough to private pay for your monthly care. So typically in this region, the average cost of a nursing home is $6,000 to $7,000 a month. So do the math. That's a lot. In fact, I'm going to do the math. But, so in general, it's $6,000 to $7,000 a month. So even at $6,000 a month times 12 months, that's $72,000. So that's a lot of money to private pay. And some people have those funds, and that's fantastic. So you're looking at $72,000 a month for a long-term care facility or a nursing home. And some of the assisted livings with memory care are really kind of running in that same rate. And I will say in this area, 6 is probably average, but I would say 6 to 7 is more. I see more on the $7,000 range. So you have to use your income coming in each month, Social Security, pensions, and that sort of thing. And then you look to your assets to make up the difference. The only time the state of Illinois or VA, their aid and attendance benefit for veterans, would potentially step in is when you're pretty much running out of funds. So we'll get to that point. So number one, how to pay for long-term care, private pay, which is your income and your assets. Another way to pay for long-term care or for, a nursing home is long-term care insurance. Critical, critical, critical. I tell every client, if they say, do you think I should do it? Yeah, I do. I think you should look into it. I think you could see if some people can't qualify because of underlying medical conditions, but this is now it's the time to look into this when you're in your 50s and your 60s and your 70s. Like, it's always worth having a conversation with an advisor as to whether or not you could be availed of some sort of insurance to cover future long-term care. And long-term care insurance policies now, I mean, I'm not a pro on them, but I've seen many of them are kind of becoming more of a hybrid approach. So old school long-term care, you paid a big old premium, and then if you never used it, you lose it, right? So that's a lot of my clients and their children in their 50s and 60s, like, oh, dad passed away and he never used it. So I'm not going to waste my money on it. But there's new products out there. So there's the traditional old school long-term care insurance where you just pay your premiums. And if you use it, great. If you don't, and you pass away, then you lose it. But there's new ones out there that are kind of a hybrid approach. So I think it's always worth having a conversation. And hybrid means maybe you just pay a one-time premium fee. Maybe you pay $30,000 and you get a couple years of long-term care insurance. Or, well, it's probably more than $30,000. But maybe you pay. Some now are long-term care insurance policies with a life insurance rider. So at least your premiums aren't going to waste, so that if in the event you don't need long-term care and you don't invoke the insurance, then at least your family will get the insurance proceeds at the end of the day when you pass away. So super, super important to kind of check into that and never poo-poo that. It's important to at least track it down and see if it's an asset that you want to acquire. It's important to do that. Next, paying for long-term care. If we can't private pay, we're out of long-term care insurance, then there's two kind of government benefits that we turn to often. First is the VA benefit, and this is a benefit called aid and attendance. And this is kind of one of the handouts I'll be giving you. Just kind of, it's a spec sheet really, and just what the numbers are. So what's important is If your loved one or yourself, you're a veteran and you served during wartime, you had to have been active duty and honorably discharged. So and then they give you these little breakouts of if you can see them, just kind of the periods of World War II, which we're just about out of. There's not many World War II veterans left. Korea, Vietnam, Gulf War, and Iraq is still open. But so this is just kind of a general spec sheet on, who would be eligible. So the first hurdle is, were you a veteran who served during wartime? The second hurdle is, do you have a disability? And when they're typically there's millions of benefits, hundreds of veterans benefits. This benefit is really typically geared towards a veteran who's maybe in assisted living or private paying care at home, that sort of thing. And then they want to see number 2, do you have a disability? And when they look at disability, you're over age 65, you could be permanently disabled if you're under age 65, but basically over 65. And then you need help with 2 or more activities of daily living. So dad needs help getting dressed, getting in and out of the shower, getting in and out of a chair, using the toilet, or even just eating. You have to feed them. So there's some very specific, it's not medication reminders. It's not making meals. Those don't count. It's the individual truly needing, physical care. And so maybe you're providing that care as a caregiver, or you're bringing somebody in, a service or an agency, to help provide that care weekly or daily. And then the third part of that test is then they're looking at income versus assets. And so that's when everything comes down to what's your monthly income coming in and what is your grand total of your assets. So if you're a married couple, they're going to look at mom and dad's assets, even if there's names are separate, like mom has her checking accounts, dad has his, mom has her IRAs. They're going to look at the combined. And currently that combined number is $123,600. So they're looking at, you can't really have more than that before you can apply for the benefit. And what's interesting about this benefit is it did not have a look back period several years ago, but as of a few years ago, it now has a look back period. So it now has a 3-year look back period. So they're looking to see, have you, just like Medicaid, the 5-year look back, have you gifted or transferred any assets for less than fair market value in the last 3 years? So be mindful. You can't just, the whole concept is you can't just dump all your assets today and become eligible tomorrow. So the VA is looking at that very closely. And the other numbers just kind of show if you're a single veteran or a married veteran, and even the veteran spouse. Maybe the veteran's healthy and the veteran spouse is ill. The veteran could apply for a benefit if they were at that income level, an asset level or below. They could potentially apply to the VA for some sort of benefit. And it's really but you have to be paying for care. So it can't just be daughter stepping in and checking in on you. That's not paying for care. Family members are considered, they give care out of love. That's how the VA and Medicaid look at that. So they may be a caregiver, but they're not a paid caregiver. And if you're going to pay a family member, this is important, you need a written care contract. If you're going to pay them and they're going to be, then they become an independent contractor or what have you. You're hiring them and you're paying them. That's income to them. You're paying that individual to care for you. And both Medicaid and VA are going to want to see a written care contract. Now, if your daughter's been doing this for 5 years and you just now are going to do a contract, you cannot go backwards. You cannot go back and pick up the last 4 or 5 years. The contract is just like hiring an agency. It has to be contemporaneous with the services provided. So if you put a contract in place and you start paying a loved one to be a caregiver, then know that it needs to be in writing. It needs to be a proper care contract, and you need to pay them monthly. So this isn't going back and picking up the last 4 or 5 years or even the last 6 months. You've got to be contemporaneous. And so they're watching that very closely and have lots of expectations on that end. And when I say they, I mean both the Veterans Benefit as well as the Medicaid agency in Illinois. Both are looking at that very closely, and there's really no wiggle room on that. So I always like to point that out as a caregiver, that if your mom and dad are just like, because Medicaid is looking at gifts of $500 or more. So if you're writing your child or the caregiver, who's the child, or family member, grandchild, whoever, a check each month, because that's, and you don't have a contract in place, that's going to be a problem. They're going to go back and look at those funds and say, why do you keep paying little Susie $1,000 a month? Oh, it's because she's been taking care of me. Do you have a care contract in place? Mm-mm. So they could penalize you for that. They'll look at it as a gift rather than payment for services. So it's important to get a care contract in place. So VA, I think we've kind of covered quickly that, and the spec sheet will help a little bit on a little more of those numbers. So I want to go next to Medicaid. What if, and you might not be a veteran, and that's fine, or your spouse may not have been a veteran that served during wartime. So then the next payer, or the payer of last resort of long-term care, is Illinois Medicaid, and then that's this other sheet that you will get emailed to you. And this I just gave you, again, just the facts, the numbers, the raw numbers. And what's important here is if you're a single person, you cannot apply for Medicaid until you're in the nursing home and you're down to $2,000 and you've sold your home. Old school, like you just put your house up for sale or they put a lien on it. Now they make you sell it as soon as possible and use that money to pay for your care before the state of Illinois pays for your care. So you can only have $2,000, and it says you can keep your home, but you actually really have to get it up for sale. And then you can keep your car, but typically if you're going into the nursing home, you're not in any position to drive. But however, maybe you have a handicap accessible vehicle or van, and the family uses that to get you to and from appointments and out of the facility. So that's kind of typically I see a client still keep the vehicle, is to use it for the loved one to run them back and forth. You can have life insurance up to $1,500 face value. It's not a lot of life insurance. So you want to review those life insurance policies as well. Are they whole life policies with a bunch of cash value? Then that's an asset that they're going to look at and potentially make you cash out before you get down to the $2,000. And you can have a prepaid burial. So this kind of circles back to what we were talking about earlier about healthcare powers of attorney having the authority to handle the disposition of your remains at death, but that it's truly a gift if you pre-plan and prepay those services so that there's no question at the time of your death what you wanted. It reduces the fighting amongst families. It reduces the stress of having just lost a loved one. I can tell you when my dad passed away, fortunately we had pretty much everything pre-planned. He pre-planned it, which made it a little easier on us girls to then just kind of wrap up final matters. But when my stepdad passed away the year later with cancer, we had not pre-planned, right? Because we're just fighting the battle. We're fighting the good fight. And so that was really tough to make those decisions when you're a hot mess and you're tired, because typically with a loved one like that, you haven't slept for days because they haven't slept for days. Things are going downhill. And then you show up at the funeral home and you're so tired, you can't make any decisions. I always say, and for some reason, good old hometown funeral homes always have the decisions that you have to make in the basement. Always have to pick up the casket in the vault. Oh, let's go down to the basement, which for Heidi Dodd means I'm not real good at going down the basement of a funeral home. So it's tough. It's tough to make those decisions, and it's better if you can make them in advance and pre-plan so your family knows what you wanted, and then also prepay if at all possible. But definitely you want to prepay. If your loved one is heading down the Medicaid path, like we are using mom's money and her care, but we're going to run out of money in 6-10 months, then you want to make sure you prepay that funeral as soon as possible. It's important, as there's some Medicaid rules that, you want to pay it like 6 months to a year prior to applying for Medicaid, if at all possible, so that, you can get that funeral prepaid, and it's not an available asset for Medicaid purposes. It's an allowable exempt asset, which is nice. And so Medicaid has stopped the ability, if you have a life insurance policy, you can, that you want to hand over to the funeral home, that's fine. But you also, if there's any cash value in it, you have to make the state of Illinois the first beneficiary. So there's some nuances with pre-planning and prepaying, but you want to get it done so that at the end of the day, if something happens to you and you are in Medicaid, you're not, your family's not left with only $2,000 to bury you, because that's really all you can have before you can apply for Medicaid. So it's not much. And then whatever income you have each month, as a single person, let's say you have like $1,500 in Social Security and $500 in a pension, so you get $2,000 a month. Well, that's going to be paid over to the nursing home, all of it except $30, and then Medicaid would make up the difference if in fact you become eligible for Medicaid and you meet all of the other requirements. But remember, Medicaid's looking back 5 years on gifts or transfers, and that's important because people, I gifted my car to my grandson. You can't do that. They're looking at gifts of $500 or more, unless your car wasn't worth $500, and then maybe your grandson shouldn't be driving it anyways. But so just be very mindful of those things, that people don't think those small gifts of love are going to be an issue, and they could very well be an issue, because when you apply for Medicaid, the question they ask in the application is, have you gifted or transferred any assets for less than fair market value? And that could also be transferring a life insurance policy. Maybe you transfer ownership to your kids so you don't lose that value. That's a transfer as well. Or you deed the house to them. That's definitely a transfer. And there's also sticky wickets with deeding homes. A lot of people will say, maybe if you add your kid to the house, it's still also your house. So they're going to go back 5 years. So that can be tricky too. So you just have to be very careful and talk to an elder law attorney, somebody who does asset protection planning, to kind of run through those scenarios, if in fact that's kind of where you're headed. Okay. I've kind of covered the gamut of what I really wanted to touch on. I feel like Chris, if it's okay, I'm going to go back to these questions.
Okay, sounds good.
Is there anything, I'm sorry, Chris, is there anything that you or Lisa think I didn't cover that I normally cover?
No, I think we've hit everything. So.
I felt so too, but I'm so used to that back and forth that I don't usually finish in 45 minutes. It usually takes me like an hour and a half.
Well, these may lead us into a whole bunch of other things, and because right now we've only got 4 questions. So if you've got any questions, go ahead and get them in the Q&A section there. Okay, first question on the list. Does putting my name on mom's finances make me responsible for taxes?
Putting my name on mom's finances, I don't know if that means actually putting them joint on a bank account. And I kind of covered that. If you're joined on a bank account, typically your parents' social security number is first. So I don't know if you would get that, how we all get those really small 1099s from our bank account. You earned 5 cents this year. I don't know if that means that you would be responsible for their taxes. Probably not, but I'm not really sure if they mean just if you're acting as their power of attorney and you need to step in for their financial power of attorney, you're responsible for getting their taxes filed, their personal 1040 filed. But I don't know if you're technically responsible for paying their taxes, out of your pocket, out of your individual pocket, I think is maybe what they're asking. But I don't recommend that you put your name on all over, that was one thing I didn't kind of mention, but when you add a child to your house because your neighbor said to, because that neighbor's husband died, and they're like, oh, when your husband dies, you just add your kid to the house, so we avoid probate, right? Because we don't want to pay a lawyer to do will, we want to avoid probate, so we add our kid to the deed. Well, your kid doesn't live with you anymore. Hopefully they've launched out and been productive and have their own home, and so they don't live with you anymore. You add them to your deed, you're adding their liability to your home. So I actually had this happen. A woman took advice of the neighbor, added her only child. I get it. Only child to her deed. She had lived in that house 50 years. It had already been paid off for, 20 years, whatever. And then the daughter, who did not live with her, filed bankruptcy. Well, guess what? That was an asset of the bankruptcy. So the mother had to buy her house back out of her daughter's bankruptcy, because it was an available asset in the bankruptcy. I didn't really think that was a thing. I always heard it was potentially a thing. And then I saw it and I was like, this is a thing. This is scary. So I don't recommend that you add your kids to all of your assets, because you're adding their liability. They cause an accident, you've made them joint owner, which is why it's nice to look at beneficiaries, because that's after death. But that kind of goes back to that first question, like, am I responsible? I don't know. It depends on if it's a joint asset that usually the parents are getting the 1099 because they're the first one on the account. I'm just using a bank account. You can't add kids to IRA. Nobody else can go to IRAs or 401ks or pensions. But I would say if you are acting as their agent under their financial power of attorney, you're responsible as the agent to get their taxes filed. Make sure that they get paid out of mom and dad's pocket, not yours necessarily. So I hope that kind of answers that. Okay.
Next one. This one's a good one. How often should the power of attorney documents, healthcare directive, financial property, last will and testament be updated? How long are they valid? I'm going to say this is a very valid question, because I know when my father passed away, the last time they had done, my parents had done a will, I was less than a year old. And I was in my 20s when it happened. So I'm going to say longer than every 25 years.
Yeah, probably. You should look at them. I always tell people, look at your powers of attorney during tax season. Although I feel like tax season's been crazy the last 2 years because of COVID. But I always say review your documents once a year. And when you're pulling out your tax stuff, it's usually with your important stuff. That's a good time to look at them. But technically, you know, you sign them in advance of your incapacity, right? So they should last 20 years. However, I will be honest with you, you know, documents that my offices did 10, 15 years ago. Now the kids are, you know, parents are starting to maybe lose capacity. Kids are stepping in. I've had some kids call me, certain financial institutions, unnamed because it's a random sampling, might not accept anything more than 5 or 10 years old. Which then we kind of have to go to the mat with the bank and say, listen, he signed this document well in advance of losing capacity for the whole very reason that the child could step in now when he doesn't have capacity. And so, you know, but I always say sometimes we just update them. If somebody comes in, you know, we just do a quick update because of that. So I would say look at them annually. There is no magic number. It's just whether the financial institution. I mean, I have clients showing me wills from 25 years ago. It's still a good will, you know. So, but it is good to get it reviewed. And the laws change. We had a major overhaul in the trust code, January 1st, 2020. Again, if you had a trust done prior to that, it should still be okay. But good to call your attorney and just have it reviewed. You know, it's just good. And powers of attorney in Illinois, the statutory, which we all attorneys typically use the statutory form, and then we kind of beef it up a little bit. Those change pretty often. So I always tell clients, I haven't seen you in 10 years. Let's just go ahead and update them because it's got you know, there's usually some nuances that I've updated. How about that horrible answer of like, I don't know, whenever.
The questions are starting to roll in now.
Okay.
Next question. Who decides if you're incompetent?
That's a good question. I typically, I mean, I don't have some medical degree, but, you know, I have a standard of which there's certain questions I ask. And as attorneys, you know, you want to know that they have capacity. What can they tell me who they are, who their children are by themselves, not with prompting. And if I'm not certain, like, because sometimes people can fool you. You know, you can sit with them for 20 minutes and they're spot on. And then the last 10 minutes of the conversation is like, so, and so I can usually gauge that. But if I'm ever uncomfortable, I just say to the family or to my client, hey, I'm not really sure where we're at here. I'm a little concerned. And then I ask that the doctor step in, you know, and that we just get, a note from the physician saying, yes, Miss Smith is, you know, is still, or she's not. And sometimes you have to get a guardianship. I try not to toe that line too closely.
Okay. Next one. Are end-of-life planning documents signed in another state still valid if that person passes in a different state?
Yes, they are. But I always tell people, it's good to, like, oftentimes, you know, parents, maybe they retired in Florida and then as they age, they kind of move back to, let's just say they come back to Illinois, or they're down in Florida and they were permanently retiring down here. I have a lot of military clients and, you know, we do their documents here and then they'll say to me, hey, I know I'm retiring in the next 3 years and we are going to Tennessee. We are going to Arkansas. So I just tell them, please give me a call and I'll happy to give you some names of, I don't know attorneys in Tennessee, but I'm part of an elder law network that, you know, typically I get good names and good referrals. So I'm happy to guide them in the right direction because I still think it's better if you, so yes, the documents are still good. But I also say if you're moving somewhere, it's always good to have your documents updated to the state you're living in, just because it makes everything a lot easier.
Okay. Next question. What if someone is no longer competent but married? Can the spouse be power of attorney or is guardianship required?
They're not competent. Just because they're married doesn't mean the spouse automatically is the power of attorney, because they have to have the competency and capacity to sign that document and appoint the spouse. So a guardianship would be necessary, which is a bummer. I know.
Okay. Question on gifting.
Mm-hmm.
I'm going to see if we can make sense of this one. 15,000 per year, 500 per month. Does this mean can gift 500 up to 15,000 per year?
All right. I know what they're going after here.
I read it verbatim for you.
No, it's fine. I have the answer questions up on my screen too. Okay, and I'm so glad you brought this up because I don't think I touched on this. Just because we can gift up to $15,000, because the IRS says we can give $15,000 per year to all of our loved ones. You know, grandparents want to give 15 a year. That's a tax rule. Medicaid is going to say, no way, Jose. That is a gift over $500, and they're going to cause a penalty. So oftentimes my CPAs and my accountants give excellent advice with regards to, yes, of course you can give $15,000 per year per person, but it needs to be followed up with, if you're running out of cash and you can't private pay your care for 5 years, you don't have 400, 500, 600,000 in your pocket, I recommend we hit a point where we stop gifting. Because it's there, you know, because let's be honest, you give all of your kids and grandkids 15 grand, who's going to pay that back? Nobody's going to pay that back because they're either paying off a student loan or put down the mortgage or spent it. They got a boat, whatever. They're just doing whatever with it. Typically, they're not going to be able to recover that money. So that's the problem is we're going to have a penalty. Mom and dad's going to be in the nursing home, applied for Medicaid, and then Medicaid's going to say, oh, because they're going to review. So just because IRS says $15,000 is okay does not mean that jives with VA and Medicaid. It does not. They're not going to allow it. And then, oh shoot, I wanted to tell you something else. It doesn't jive with VA and Medicaid. And then, you know, at some point you got to hold on to your assets. Or they'll say, oh, I'm going to have little Johnny and little Susie park that in an account. It's still an available asset for Johnny and Susie. They get divorced. You don't think that ex-wife or ex-husband's gonna be like, hey, I remember there's 50 grand sitting in an account for Grandma Smith. You know, so it's not recommended.
Okay.
Yeah, it's a problem.
Are the beneficiaries of your irrevocable trust responsible to pay for expenses left behind that might be more than the value of the trust?
That's a really detailed question. It depends on the trust and the whole situation. I'm sorry, that's a review the trust and sorry, Pam, I don't know the answer. I mean, that's a specific question. Maybe not. Yeah, that's
depends on the circumstances of how the trust was written. And
yeah, that's reviewing the trust in detail and all of the circumstances around the estate.
Okay, I think this next question, if our documents completed in 2005 for living trust powers of attorney will need to be updated now. We've already covered that when.
And they're still good. They should still be good, but it's been 16 years. Wouldn't hurt. And the other time you want to review powers of attorney in a trust, like I said, I try to say look at them annually, is if there's a major change in people that you've named, right? So that's why I always like to name spouses first, whatever, and then the kids. But God forbid there's a kid that's passed away or a grandchild. Oftentimes when you lose a loved one, sometimes your distribution or your mindset changes, right? Or little Johnny is not the person anymore. He's been misbehaving. He didn't handle his affairs very well. So now you're like, I don't think he's my person. I think I'll put him third rather than first, or I'll take him off. So anytime there's a change in circumstances with the people you've named, that's definitely a time to call and make some updates.
Okay. Next one. If your only asset is your home, do you advise a revocable living trust?
That's a loaded question. It depends. Back in the day, that's all. If you were trying to avoid probate, then that was one of our few options to avoid probate was to, and many people we've done revocable trust for that just hold a home and maybe a bank account because it's acting as your will. You do a will, but you also have a trust. So it still handles the disposition of your estate. But now in Illinois, like Missouri and many other states, we have what's called a transfer on death deed. And it's a beneficiary deed. So if you just have, I don't know the circumstances, you just have a home, you could potentially, and I only like to do them when there's 1 or 2 kids and the kids get along, you could potentially transfer a house via a beneficiary deed, which means you still own the home. I, Heidi, own my home, but at my death, I want it to pass to little Bobby and little Susie in equal share, then it would pass to my children. But I don't know what else is around those circumstances. Do you have a special needs child? Do you have a special needs grandchild? Who's getting your money at the end of the day? So a trust may still be appropriate even if you just have a home. I do sometimes trust. They seem like overkill, but it's the best way to accomplish the end result of how they want items distributed, if that makes sense. So it depends.
Okay, next one. If your parent had a revocable trust and then later in life made an irrevocable trust, does that new trust cancel out the old?
These are great questions. Dang. It depends. Sometimes people take everything from the revocable living trust and they now move it into an irrevocable trust intentionally to protect everything. Because like I said, revocable doesn't protect you from long-term care. Irrevocable after 5-year look back, if everything's correctly funded, should help protect you from long-term care or, protect those assets that you moved in. So if your parent had a trust, does it cancel out it? Not necessarily. I will be honest with you. In my practice, I've had clients come to me that they've done a revocable and then they maybe met with another attorney who's now retired or something that did an irrevocable. So they have both and they canceled the revocable one. They revoked it. And then one of the persons died and they had a couple insurance policies that paid out to the revocable policy they forgot about these policies and they paid out to the revocable trust. And so it was kind of a mess because the revocable trust wasn't in play anymore. So sometimes it doesn't mean they cancel each other out. No. I sometimes leave the revocable one open and unfunded for that very reason. So it depends. It depends what the irrevocable trust says. I hereby cancel, but those are two separate documents, so they should have two separate transactions related to them. In my world, that's how I would handle it.
Okay. Next one, it's kind of a long one. I am POA for my aunt and trying to help her with finances and healthcare. She was to pay her own bills, but is making mistakes, paying more than due, multiple payments, paying for things for others. She feels she is competent, but it fluctuates. I've been thinking about getting a PO box so she doesn't get bills first. Of course, she could change address. Is it time to get guardianship? Someday she could appear competent.
Mm-hmm. Oh, you're in a tough spot. That's a good question. So sometimes just because that's a great question though. Sometimes we have powers of attorney and we still have to get a guardianship. I always tease before my partner retired. Sometimes you see those older gentlemen and they see them on the news. Oh, Bobby and Frank, good old buddies, took a ride together one day and they ended up in Oklahoma. I always think most of the time those end up being my clients. And so they were competent and they had, when they signed their powers of attorney, now the kids are like, what do we do? Because they're still clicking. They probably shouldn't be driving, but they're competent. They have good days and bad days. And sometimes you have to go in and get a guardianship because the power of attorney, they're not going to allow you to step in. They're just not. And you need court involvement. And when you get a guardianship, you have to petition the court. You have to give everybody notice, including your dad, if you're trying to get guardianship over your dad or your aunt. And then a guardian ad litem is appointed, which is a neutral third-party attorney who comes and interviews your aunt and you and make sure, and assesses all of the assets and says, yep, you're the right person, or I don't know about that. So it's tricky, but you're in a tricky spot. I would probably maybe say, let's go talk to the doctor, Aunt Sally, and see, I think it's time to try to let me step in. And this is a tough one. I know you're kind of paying your bills are getting a little wonky. But you got to be careful that you start moving things out from underneath her. And then she says, hey, my niece is, So, I mean, I think I'd try to take her into the doctor and talk with her with the doctor first. And that's just a sticky wicket. I know that's a tough one. Because she's coming back, she's in and out of clicking and not having good days and bad days. Yeah.
This is something common. This is a question we get a lot in our office. So
I think it's good to try to get the doctor involved and then just say she's no longer able to handle her affairs. And maybe you do have to get a guardianship. And then, you show that you were the appointed power of attorney. That doesn't mean the court's going to appoint you, but it's evidence to show that you were the person they chose. And sometimes a guardianship is what you're going to need to get the authority to then step in and be like, all right, I'm stepping in. I'm going to show the banks I'm guardian. I've been appointed. So yes, a guardianship may be in your future, unfortunately.
Okay, next one. I think we're going to get into spousal impoverishment with this one.
Yeah.
In regards to Medicaid, when does my monthly income need to be $2,739 or less? Is it when they are in the long-term care facility? My husband has early onset Alzheimer's and has been on disability for nearly a year.
A great question. So, and I only covered, you can keep, if you're single, you can have $2,000. If you're married, you can have $109,560. And, oh, hey, Mama.
I muted her. Sorry, Sandra, I muted you.
I think I sent her the link. So anyways, on a married couple, you can have 109,560, and that's when the 2739 comes into play. So, but if you have already your income and your husband's income equals 5,000 a month, like Social Security and pensions and the disability, then you're likely never going to hit that 2739, right? Because your income, your monthly steady income is over the 2739. And so if it's over, but you're down under the 109,560, you may have to pay the overage. So if you have 4739 a month, you'll get to keep 2739 between you and your husband's income, and then you may have to pay the overage. There's some exceptions, but not many. So, if like I said, and sometimes it's just easier to private pay than to pay the overage, because you got to run the numbers. I don't know if that answered the question great, but if you've got $4,700 a month in income, that's not going to change, so you're going to have to pay the overage in general, probably pay the overage over to the nursing home. And then the state of Illinois would pick up the difference. So if it's a $6,000 tab, you keep $2,739, you pay over $2,000 of that, because you had $4,739, then the state will maybe make up the difference. But yeah, you may have to pay the overage.
Okay, she just added an add-on to that, just a clarification question. So is the 2739 is combined income?
Yes. Yeah. Yes. Not just his or not just yours. Yes. Combined income. Oh, and then, so she just added another question. I can adjust my income because I work for myself. Yeah. I mean, it's a numbers game,
Before we go to the next one real quick, Joan, I see you have your hand raised. If you have a question, if you could please put it in the Q&A portion, that'd be great. Thank you. Okay, next question. Any advice for someone who is essentially an only child? My parents intend to make me medical and financial POA, executor of their will, and trustee of a trust for my incompetent older brother. It seems like a lot for one person. Are there entities that can handle some of this?
Yeah, that's a great question. So, right, only child. You might want to turn to some cousins. They have some nieces. I mean, you can turn to some cousins, but also executor of their will and trustee for my incompetent older brother. Oh, you're essentially an only child. So they may, if it's a lot for one person and you're not that's just not your bailiwick, which is totally understandable. Their corporate trustees is who we often turn to. I always try to turn to family first. Do they have, the mom and dad siblings are probably aging too, so you may not want to turn to them. But, I would turn to your cousins. Do they have any nieces and nephews that you're close with? That's often where we turn next. But then a corporate trustee isn't a bad thing. Mm-hmm. But a corporate trustee will not do medical. They're not going to step in and make medical decisions for your parents. And they don't really like to step in as financial power of attorney either. Some teeny tiny small banks and small towns will do it. But in general, they will all just step in as like executor and trustee over assets in the trust. But yes, corporate is always a backup. Mm-hmm. Corporate trust officer.
That's the problem and the benefit of being an only child.
Yeah.
The problem is you have nobody else, no other siblings to rely on. The benefit is you don't have to argue with any other siblings.
Right. Right. But your chain of command is pretty short. The backup plan.
Okay. Next one. If the person who made an irrevocable trust has passed on, can the trust be broken by the beneficiary? Well, I'm going to really keep my mouth shut on this.
It depends what the trust says. I don't, if the trust is still, depends. Could be a trust set up for a kid who said, mom and dad said all of your money is going to go in a trust, even if we're gone, because that's the point, because you're a spendthrift. It truly depends on the trust.
All right, next one.
These are complicated questions, by the way.
They are. They're very detailed.
Man, you guys are hitting me hard.
Where should power of attorney documents be stored for access? Oh, this is a great question. This is another one that we get a lot. Where should I put these?
Yeah. So we, when we prepare documents, we have an original, plus we give you a copy. And so the copy, and attorneys love to make copies. You know, we kill a lot of trees. The copy, I always say, should be kept at home. And powers of attorney, most places are happy just to see a copy of it. I always say keep your originals in the safe deposit box or in a safe, or if you don't have a safe at home or a safe deposit box, that's okay. I always write a note. You would not believe almost every day I get a call when somebody passes away. Do you know where my mom's documents are? I'm like, hang on a second. I look through my file because I always put a note. So you should try to keep them in a safe, like the original will, the original trust documents. I typically don't advise that your powers of attorney go into the safe deposit box, because if you have an emergency on a Saturday or a Sunday, I feel like whenever you get sick or your kids get sick, it's Friday afternoon. And then you can't get to the bank. You can't get into right now it's hard to get into the bank anyways or get into the safe deposit box. So I say keep your powers of attorney at home with you, and that or you can put the originals in as long as you keep copies out, and then your originals go in the safe deposit box or in just a fire safe proof box, or if it's your file cabinet, put them in your file cabinet, but just make it very clear where those documents are.
Yeah, that was the other thing I was going to add. If you have those documents, make sure your POAs and your executor know where those documents are.
Right.
Let them know. You might think they should know, but they may not. On that.
Right.
All right.
And make sure they know that they're the people. Like if you name somebody, make sure you tell them.
Yeah. Because some of them may not be able to pick up the phone and call their lawyer because the lawyer may not be in practice anymore.
Right.
So, all right, this is the last question.
Okay.
My mother's POA states that in order to attain the power to take care of her affairs, 2 doctor statements are needed. She has been and still being seen by 1 doctor over the past years, but now is in long-term memory care. Where do I turn for the second physician?
My mother's POA. Oh yeah, and some of them do say that you need 2 doctors. She's been in line. So
could she turn to the doctor that's on staff at the long-term care memory?
That's what I was just trying to decide. Is the one person that's seen her given the note, was that the one on staff, or I mean, you may have to, I guess it depends. Since she's seen the one on staff because she's in a facility, I would ask them for one. But if they're the ones who gave the first one, which is kind of what I'm thinking, that's the problem.
She just added, it is the long-term care staff doctor.
Okay, so they're the one who gave the first one. If she had another doctor prior to that, I would maybe try to get a visit and just, wonder if the other doctor on staff has other, sometimes they have a backup doctor, or you have a medical director who's a doctor, but somebody that, clearly it needs to be somebody who's seen her. You can't, most doctors, I don't think, I've never seen it. They're not going to randomly just meet you once and wing it. So you may have to establish a relationship with an outside doctor, or if you had an outside doctor, reestablish that relationship and say, hey, I need to get my mom in for this reason, and, just get some checkups in or something. Yeah.
Okay. Yeah. Anybody else have any? That's it. We've cleared out the question box. Does anybody else have any questions? I'll give you just a couple of minutes if one's popped in and you want to ask it before we wrap things up here.
These might be the hardest questions I've ever had. These were technical. Great. Yeah. You're welcome, Pam. I feel like there was one more thing I wanted to cover. We talked about Medicaid. I think it's just, VA, those are great benefits out there. You'll see the spec sheets on those. Just being very, very careful about giving things away. I'm really protective of clients' assets at this stage in the game. When they're faced with some long-term care, let's not give money away. Let's not make the gifts, because the accountants are right. You can gift the $15,000 and then they get stung later because they've gifted it with the tax reasons, but not for, Medicaid and VA think that you're giving it away so that you can become eligible. So I always say for caregivers, take care of yourselves. That's most important. Or you can't take care of your loved one. Get everybody's affairs in order, yours and theirs, while you can. And if you need a care contract, get a proper care contract in place. Pay it monthly, because that's a big one that caregivers get stung with. They quit their jobs to move in with mom and dad or what have you, and then you can't go back to do that. And so those are other, I like to try to point out the kind of unintentional mistakes that caregivers or loved ones make, that kind of sting them later. So main thing is take care of yourself so you can give your loved one the best care needed.
Okay, we got a couple more. First one, when do you start the process of applying for Medicaid? Ooh, that's a loaded question.
Yeah, that's okay. So, this is a great question. Facilities will tell you when you enter a facility, they'll say, we'll do this for you. But if you're trying to do some sort of planning, like asset protection or just Medicaid planning, maybe mom and dad have a couple $100,000, so you're not there yet. You're not at the 109,560. You need to prepay some funerals. Always, always, always do that. It's best to sit down with an attorney who does the planning and get a plan together. Because if you apply for Medicaid too early, like let's say you have $400,000, but you're like, I want to get in on this Medicaid thing. You apply too early, your spend down from the 400,000 to the 109,560 can only pretty much be on medical, right? So you kind of limit your ability to be like, well, I wanted to buy mom and dad a new couch for their assisted living, or I wanted to buy them a new bed, or whatever. So just while the facilities absolutely can help you, there are attorneys and other consultants out there that can assist you with that Medicaid. If you've got something to protect, you want to at least have a consultation with an attorney who can kind of talk you through. I always like to give, and I'm not actively doing the irrevocable trust anymore. We kind of capped that area of practice because it was hot and heavy for so long. I want to be able to service the clients I brought in over the last 10 years on that. I still do estate planning and wills and trusts, but you want to talk to an attorney who can, and I talk through with my clients all the time. Okay, here's our options. Mom and dad have $400,000. We can do nothing and know that they've got this money to pay for their care. And when they run down to those numbers, then they run down, they run out of money, then you apply for Medicaid. But if you're going to work with somebody who's going to help you with that application and consult with you, you want to get in 6 to 8 months before you run out of the money, so that you have, or earlier a year. If you want to do some planning, you want to get in 5 years before that, right? So, but you can't apply for Medicaid until you're in the nursing home, in the bed. And now I'm going to go for a single person, down to $2,000 or down to the 109,560. And if you're married, you can protect the house. The healthy spouse can stay in the home. Okay. And then the other numbers are about the same. Ooh, now I remember what I wanted to tell you guys. They're going to ask you for 5 years of bank statements, 5 years of Edward Jones statements, 5 years of Merrill Lynch statements, CDs, any account you have. They're going to ask for 5 years of statements. They're going to ask for life insurance policies. Save that stuff, because asking the bank to recover those bank statements, it's so expensive and sometimes impossible. So keep 5 years of bank statements at all time. Keep 5 years of investment statements, all of that at any given time. Just start stacking it away in a folder. Okay. And if you buy something, I knew there was something else I want to tell you guys. So it's the 5 years. Keep your statements. And also if you purchase, you run errands for your mom and dad right now. Oh, I run a Walmart. I just put it all on one bill. If your parents are reimbursing you legitimately, like you're just picking up their monthly items, you need to document that very well. You need to save the Walmart. I always say, I know it's a pain in the butt, because when you get behind somebody who says I have 2 transactions, you're like, what? I'm in a hurry. But just do it. Hold up the line. Get out mom, pay for them separately. Even if you're paying for them, pay for them separately. Keep that receipt for mom and dad, and then have them reimburse you. And you can put reimbursement for Walmart. Keep all those receipts for 5 years. Keep all of that stuff, because, Medicaid can come back, review those bank statements and be like, how come they're writing you a check for, $650 a month? Oh, that's because I paid this bill every month for them and then they reimburse me. So you just have to have proof of all that stuff. So, because that's another common thing caregivers do. They just run their errands and pick everything up on one bill. So you want to be able to prove that reimbursement and save 5 years of bank statements. So I think that answers when you start applying for Medicaid.
Okay, I'm going to tag this one onto that because it's kind of, it's attached. In regards to Medicaid, can we spend money on home improvements and daycare or home care for husband? I
Should
think
be
that-
as a spouse. Yeah. So if you're home, you're living in the home, and your spouse, of course, if your spouse needs, you can. It's just gifting or transferring assets for less than fair market value. So if you're paying for somebody to come into the home, or you're taking them to St. John's daycare, or you're paying for absolutely, and home improvements. Yes, you in general should not be a problem because you're still allowed to stay in the home. Was there another home improvements daycare?
Yeah, I think that was it.
Okay.
Okay, one more, two more questions. It is my understanding, she said it's not a question, they say it's not a question. It is my understanding that you can take a copy of your healthcare POA and advance directive to the hospital and have it filed on your records. Now, I'm gonna step in real quick on this one.
Okay.
Yes, I know you can, but from the standpoint of a caregiver, another caregiver, you really need to have those documents in your hand when you go also, because you may say, oh, they're on file. I'm going to tell you, a lot of times a hospital can't lay their hands on them.
Right.
That's my portion as a caregiver specialist. That's my answer to that question.
100% true. I always say, make an extra copy, or a lot of times clients will ask me, I'll make an extra copy for the doctor's office so that they can just give it to them. A lot of them will scan it. Even those that are super savvy on this stuff, they scan it, but it's not always it's not popping up in the system. I always say, leave a copy in your glove box of the car. If you really are you're in a care situation, yeah.
Okay, one more. My parents both ended up in the same facility after my dad fractured his femur. He had been 24/7 caregiver for mom. They did not plan ahead and left a big hot mess for me to clean up. What pre-planning do you suggest for someone at my stage of life in my 50s so I don't do this to my son in the future?
Get your wills, get your trusts, get your powers of attorney in place, whatever that is. Look for long-term care insurance now while you're in your 50s. Yeah. I'm actually getting ready to get my own quote, and I'm not 50. But my husband's over 50, so he's like, what? I'm like, listen, this is what I do for a living. We need to get a quote.
And I actually think she's taken the first step by joining us today.
Yeah, exactly. Yep. Mm-hmm.
On that. Okay, that's it. And we are almost at time. Lisa, I'm gonna turn it over to you. Heidi, do you have anything else you want to tag on? Okay, Lisa, I'm gonna turn it over to you for
Heidi, thank you for the information. And I always learn something. I've listened obviously numerous years, and you maybe because you age and you hear things a little differently, because obviously life has really changed for everyone. So thank you, Heidi, for your time. Chris, thank you for all your skills, because you do a great job. And we want to thank everyone that got on here today. There will be an email later that we can send out with attachments. We will have to have surveys completed, because that's the only way we can get better and know what you folks need to hear. We look forward to you joining us next Saturday when our friends from Adaptive Equipment and Caregiver Corner, Cindy and Christina, if you haven't heard them, they are amazing and they're fun and they're knowledgeable. So be here next week at 10. Put it in your calendars, put it in your phone. We can send you a carrier pigeon. We want you to have a great week. We want you to stay well. And Heidi, again, thanks for your expertise.
My pleasure.
Thanks, everyone.
Heidi.
Be well.
Next week. Bye-bye.
Bye-bye.